Hi, I'm Susan O'Toole. I'm an attorney here at Beresford Booth in the Family Law Department. I'm doing a webinar today, Divorce 101, Basics of Parenting Plans, for all parents who are in the process or thinking about getting a dissolution, which is the legal term for divorce. And so I thought I'd walk you through some of the basics of parenting plans that you will need to think about in your dissolution. So a parenting plan is basically an outline for the court of what you as the parent think is in the best interest of your children to be adopted in the event of your divorce. When there are children involved in a dissolution, the court is charged by the legislature with making decisions in the best interest of the children. And this is one of the most important roles of the court. The court feels like you and your spouse are adults. You'll be able to figure out your lives and live your lives, but there isn't really anybody looking out for the children in the context of a dissolution per se, because children often don't have a voice in those types of things. And so the court is charged with always making the decision in the best interest of the children. You file your parenting plan either at the time that you file your divorce or before the final divorce orders are entered. And it basically tells the court what you, as a parent, think is in the children's best interest. Since this is a divorce, oftentimes parents disagree on what's in the best interest of their children. So what happens is that each parent will file their own parenting plan. The court may choose one of those, but usually it's a combination of the two when the court is choosing to do either a temporary parenting plan or a final parenting plan. So I'm going to go ahead in just a minute and share my screen, and we're going to go through an actual parenting plan. I'll describe what the different sections are for you. I'll talk about the factors that may limit parenting time or decision making, and I missed a word there. There's supposed to be the word limit there. We'll talk about the decision making part of it, dispute resolution, how parenting time is set up, holidays, transfers, that sort of thing. And then some other suggested clauses that an attorney may, think that might be appropriate for your situation, or that you might want to add if you're trying to represent yourself. Which I, as an attorney, generally don't recommend that, especially when there's children involved. I think that parents need to be represented as much as possible. So there are two different types of parenting plans, temporary and final parenting plans, but it's the same form. And so what I'm going to do now is I'm going to stop this share and I'm going to go over an actual parenting plan with you. And then we'll talk about the difference between temporary and final parenting plans and how the courts have to navigate setting up those types of parenting plans. So let me stop this share and then share another screen with you, which is this one. Okay, so let's see here. This is a parenting plan that, and it's kind of in an odd place here. Let me see if I can get it over here. All right, there it is. All right, this is the basic form for a parenting plan in Washington State. You would, the top part is, where the case information goes, names of the parties, case number, that sort of thing. And here is the parenting plan. And if you're doing a temporary parenting plan or a parenting plan that each parent might be suggesting, it's a proposal. On a final parenting plan or a temporary order, when it's signed by the court, then this box is checked. Here you're listing your children's names and ages, so the court knows, what type of parenting plan it's thinking about. Is it an infant parenting plan? Is it a teenager parenting plan? How old are the children? What are their names? So the court can know, who your family is. This section 3 is at the very top, and it's kind of a preliminary section that the court needs you to fill out to tell the court if there are any problems that the court needs to consider in making decisions for the children. So these are called 191 factors after RCW 26.09.191. And these are the types of factors, the most serious factors that the court will consider in putting limitations on a parent, whether it's on parenting time with the children or whether it's on decision making, whatever it is. So the first one, 3A are the most serious ones: abandonment, neglect, child abuse, domestic violence, assault, or sex offense. And then you go through and you tell the court if, first of all, if neither parent has any of these problems, which we always hope, then you would check this box. If there are some other issues here, you would check some of these boxes. And you need to also, when you file a parenting plan, when you're talking about these sorts of things, you'll need to give the court more details. And so I, as an attorney, would help you work through a declaration that tells the court the details. What has happened in terms of domestic violence in your home? What are the sex offenses? That sort of thing. And then Section 3B, Section 191 factors in Section B are a little bit less serious than Section A, but they're still reasons that a court may limit a parent's involvement in a child's life. So you can check neither parent has these problems, or you can talk about neglect, an emotional or physical problem, substance abuse, if there's alcohol abuse or drug abuse, lack of emotional ties, maybe the parent hasn't been involved in the child's life a lot, abusive conflict, if the parent is constantly trying to get into arguments or fights or file court papers, that could be abusive conflict. And withholding the child, if the parent has taken the child and run with the child and you've gotten the child back, you might check the box that says withholding the child. And if there's other reasons, you would check other reasons, and then you would describe those for the court in your declaration. So Section 4 builds on Section 3, limitations on a parent. So if you haven't checked any reasons in 3A or 3B, then you would check this box, and the court would know there's no reason to limit either parent in their time with the children or the decision making or some of the other things the court may choose to do. If you feel like, okay, we've listed some reasons up there, but we're not going to have limitations. Say you say someone has a substance abuse issue, but that person's in treatment and they've been in treatment for a long time. They've stopped drinking or using drugs, and they've been a good parent. So you say, you might check no limitations despite these reasons, and then you would tell the court why. The other parent has been going to AA and has been sober for 2 years, and even though they have that issue, I don't believe that their parenting time should be limited. And then the next one is kind of you as a parent telling the court what you believe to be the limitations on the other parent. If it's something significantly serious, like there's been, child sexual abuse by the other parent, you might check the box, no contact with the children. That is a pretty serious thing to ask the court for. Of course, believe that, and this is from the legislature again, public policy reasons, they believe that, most of the time parents should have contact with their children. It has to be something pretty serious for the court to limit contact with the children. And the next option you could check is limited contact, as shown in the parenting time schedule, sections 8 through 11 below. And that is where you say sections 8 through 11 talk about the holidays and how you want to set up your parenting time. And so you're going to say, okay, I just want what I've listed below to be the contact with the parent. And then limited time contact as follows. And this is where you could get creative. And if you don't want to go down below and check all the boxes, you might just say, every other weekend from 3 to 6 p.m. with the supervisor. That might be something that you might put limited contact. You can check the box that says supervised contact. All parenting time shall be supervised. cost of the supervisor must be paid by, usually people say the other parent. If they're the person that you need the supervisor for, you feel like they should pay for the supervisor. Do you want a professional supervisor, or do you want a non-professional supervisor, a family member or a friend, someone that you would trust to have the supervised visits between the other parent and your child in their home? And then you tell the court, okay, I believe that the dates and times of supervised contact will be, and again, you can either fill out sections below, or you can give, a short definition to the to the court, excuse me. And then if there are other limitations or conditions you want during parenting time, you might say with an infant, you might say something like, only licensed drivers who have an infant seat that's up to code are allowed to transport the child. Or, there might be other things that you might want to have happen, like something I'll see a lot when there's an issue with substance abuse is the other parent will not drink or use drugs before visitation with the child, before or during visitation with the child, that sort of thing. Another thing you can ask the court to order is evaluation or treatment. You can say the other parent must be evaluated for, and some of the things you can say are substance abuse, domestic violence, anger management, mental health. You can put those things in this section. And then you can say, I want the other parent to start or continue and comply with treatment as recommended by this evaluation up here, or as follows. And then you can put details in there. And then you can check a box that says, provide a copy of the evaluation, the compliance reports for treatment. And you can put who you want to get those. Most of the time you put the court and me and my attorney, so that I can see that the other parent is in compliance with the treatment and doing what he needs to be doing, he or she needs to be doing. And then you tell the court, okay, so if you order court an evaluation or treatment and the other parent does not follow through with those, what happens? And a lot of times this will be something like, if the other parent doesn't do those things, then only supervised contact with the children, or maybe no contact with the children until they've gotten back into treatment. So, it kind of depends on the seriousness and the effect of whatever the issue is on the child, the potential effect. But you make sure you tell the court why. You say, this is what happened. This is what I believe should happen if the other parent is not following the evaluation or treatment requirements, and this is why. The next section, decision 5, is decision making. And this has to do with who makes kind of the big decisions for the children. The first section says when the children are with you, you are responsible for them. You can make day-to-day decisions for the children when they are with you, including decisions about safety and emergency health care. So that means that if there's no problems listed above, or if you're allowing, if you're telling the court, I want to allow visitation, even though we have those problems above, then when the child's with either parent, that parent is responsible for them. But major decisions is another category. So if you're making major school and educational decisions, where your kids are going to go to school, whether they're going to go to private school or public school, that sort of thing, and then healthcare, where who their doctor's going to be, who their dentist is going to be, who's going to take them to the doctor and dental appointments, those sorts of things, whether or not they're going to have a surgery if the doctor recommends it, those sorts of things are the major decisions. And then often people will put other things in here, tattoos, piercings, whether or not kids can get married, depending on how old they are. There's some other categories that people can put in here. And if you want the court to allow the parents to make these decisions together, you check the joint box. And if you want, and generally, if you're the parent who wants to limit the other parent's time, a lot of times you'll say, I believe I should be the person that makes the major decision. And so you would check this box if it's limited, and you put the name of the person that should make the decision. And then you have to tell the court why. I mean, why is there a reason to put limits on major decision making? If there's no reason, check this box. If there's 3A problems, as we talked about above, then then the court is mandated, the court must limit the decision making. If there's 3A problems, major decision making should be limited because both parents are against decision making, shared decision making, or one of the parents does not want to share decision making and this is reasonable because of, and then you have some options here. So if you're asking the court to limit major decision making so it's not joint, you need to tell the court why. The next section is dispute resolution. This has to do with situations where you and the other parent disagree. And it's generally disagreements about decision-making, shared decision-making, or about what parts of the parenting plan mean. And so the court wants you to tell the court what you believe you and the other parent should do to try and solve these disagreements. You can choose, the parents will go to mediation or arbitration or counseling. These are usually options where the parents can at least talk with each other or present each other with proposals and consider each other's proposals. And then, you know, a mediator is a voluntary decision. You know, you try and come to a compromise voluntarily. An arbitrator is someone who will make a decision for you without going to court, but you both submit usually written materials. And counseling is, you know, just what it sounds like. You know, if you've got a counselor that the two of you trust, maybe you've been to marriage counseling or parent counseling, and this is an issue involving a child the counselor knows about, you might check the counselor. And then some people just check the box that says court. If you're in a situation where there's been serious domestic violence, you might just want to go to court and not have to deal with the other person in any other kind of context. If you do choose to go to mediation, arbitration, or counseling, then we talk, you know, you have to tell the court, how am I going to tell the other parent that I want to do this, that there's a disagreement? And then who's going to pay how much? You know, a lot of times people will say they'll pay 50-50 if they go to mediation or arbitration. And then another option, when you do a child support worksheet, it tells you based on the parental income, who should pay what percentage of the child's costs and expenses. And so you can also tell the court you want to do it based on those proportions. Or you can do it as decided through the dispute resolution process. So we want to go to mediation. I feel like that this issue is 90% the other person's fault and not mine. So, you know, you may check that box. So we decide when we go to the dispute resolution process, when we go through it, who's going to pay. And you need to understand that when you go through dispute resolution, like mediation or arbitration or counseling, preference or court, preference shall be given to the carrying out the parenting plan. Agreements have to be signed in writing. And you can get sanctions or penalties if you haven't followed through with the dispute resolution process without a good reason. And you can go back to court. If you go to mediation or arbitration, you can go back to court. Custodian. Custodian is a word, you know, who has custody of the child is a word that people think is really important, but it really isn't as much these days. There are specific forms, state and federal forms, where they require, you know, someone to be designated who has custody. But in our state, having custody really doesn't mean that much. It really comes down to parenting time. So sometimes people put both people's name in the custodian box. Other times they'll pick one person who's going to be designated the custodian for those kind of forms. But it isn't nearly as important as it used to be. Now we talk in terms of who has parenting time and who has what parenting time. And this is parenting time schedule, the residential provisions. And if you filled out the part above where you have a short statement to the court that talks about what you think the parenting time should be, then you can skip this one. If you're going to use this, you first have children under school age during school, and you can say does not apply. All the children are school age. The schedule for children under school age is the same as for the school age children. And then you go through and you say, okay, children are school age are scheduled to live with which parent, except when they're living with the other parent. And then you can pick days and times that you want to do that. Same thing applies to the school age children. The section is exactly the same, except for you tell the court when you want the schedule to begin. And then you fill out, okay, every other weekend from this time to this time, or weekdays, or whatever it is you want to do. And then you do the same thing for the summer schedule. Most people, if their kids are in school, they want the summer to begin according to the school calendar, or you can give the court a different day that you want summer begins and ends. So you can say the summer schedule is the same as the school schedule. You can say it's the same, except that each parent will spend 1, 2, 3 weeks of whatever you want to do of uninterrupted vacation time with the children each summer. And then you say, the parent shall confirm their vacation schedules in writing by the end of, a lot of people say April or March, so that you know what weeks your spouse is going to, or your former spouse, the other parent, is going to take the children on vacation, and vice versa. And then if you want the summer school to be different, then again, you fill out this section that tells the court how you want it to be different than the school schedule. And then section 10 is holiday schedule. And this is very detailed. It lists lots and lots of holidays. And, you can check the box that says the holiday schedule is the same as the summer and school schedules. Or you can say this is the holiday schedule for all the children or the school age children. And then this holiday schedule goes through every holiday. A lot of times, we'll have parents alternating years, odd year with mom, even years with dad. And then the begin and end daytime, and other things that you can do. You can say, well, Martin Luther King Day is a Monday. It's always a Monday, and so we'll just say that the children just stay with the parent who has the children for the attached weekend. And then we go down and we do President's Day. Some schools have a midwinter break. And so you tell the court, what you want to do with the midwinter break. Then you talk about spring break. Mother's Day, a lot of times mom gets Mother's Day every year and dad gets Father's Day every year. Then Memorial Day, again, Father's Day, 4th of July. 4th of July is kind of a weird one because it can fall anywhere in the week. And so sometimes people just want to keep it in the summer schedule. Sometimes they want to split it. Just kind of depends on what your family does. Labor Day, Thanksgiving Day and break. When does it begin? When does it end? A lot of people say it begins when the kids get out of school on the Wednesday before Thanksgiving. It ends Saturday or the Sunday or maybe Thanksgiving. Whatever you want to propose to the court that happens in terms of Thanksgiving. Winter break, Christmas Eve, Christmas Day, New Year's Eve, New Year's Day, children's birthdays. And this is something that it didn't used to be in parenting plans, but it's really important for families to figure out, okay, so who's going to have which child this year? Do we have them, odd years with mom, even years with dad? Maybe this child is even years with dad and odd years with mom, and maybe this child is vice versa. And then we tell the court all 3-day weekends not listed elsewhere, because sometimes there's like teacher in school days where the kids are off, federal holidays, that sort of thing. And then there's also a neat little thing now on the parenting plan, other occasions important to the family. So Easter, Halloween, some of the other holidays that go, the Chinese New Year or Hanukkah or something like that, whatever type of occasion is important to the family. And you can list these here and include them in your parenting plan. Section 11 has to do with conflicts and scheduling. What happens if there are conflicts between the different holidays you list above and the summer schedule or the birthdays? And so you tell the court what's most important. Should the named holidays be followed before the school breaks? Should the children's birthdays be followed before named holidays and school breaks? Whatever you want to do there. Next section is on transportation arrangements, and this is a pretty important section of the parenting plan. How are we going to exchange our children? Are they going to be picked up and dropped off at each parent's home, school or daycare when in session, some other location? If it's a domestic violence situation, maybe you're dropping the kids off and picking them up in the Costco parking lot or the local police station, public places. And then who is responsible for arranging transportation? The picking up parent or the dropping off parent? And that's another important thing. And then section 13 gives the statutory language that has to be included in all parenting plans on what happens if somebody wants, if the parent who has the more time, the majority of the time with the children is planning on relocating. And this is really important, and I'm not really going to go over it a bunch today, but this has to be in all parenting plans so every parent knows what process they have to follow in terms of giving notice to the other parent if they plan to move. And then section 14 is other, and a lot of times, attorneys will have clauses that they suggest for your specific situation, and sometimes for all situations that go in section 14. Like one I'll always suggest is neither parent shall talk negatively about the other parent or allow anyone else to do so in front of the children. I mean, I think that that's an important thing, and I think that, in my opinion, it should go in almost all parenting plans. Sometimes there's something to do with passports, traveling out of the country, traveling out of state. There's a variety of clauses you can put in section 14, and I have a cheat sheet I give to my clients and say, look through this and see which ones you think you would like to include in the parenting plan. And again, we're talking about whether or not this is a proposal or a court order, and two different boxes. If you're the parent submitting it to the court, you'll check it's a proposal, and you have to sign it. And you have to say, I declare under penalty of perjury under the laws of the state of Washington that this plan was proposed in good faith and that the information in section 3 above is true. So when you're saying the other parent has issues with domestic violence, you are swearing under penalty of perjury that that's true. That's section 3 above about the problems that the other parent has. And so this part is just kind of signatures of attorneys, signatures of court, depending on what, whether it's a proposal or a signed order. So let me stop that screen share and then go back to this one. So there are two different types of parenting plans. The first one is a temporary parenting plan, and the other one is a final parenting plan. So when you file for dissolution, a lot of times your court dates will be 6 months or more out because of how busy the courts are, and that's just kind of the reality. So between the time you file for dissolution and when you get your final parenting plan, you'll need something in place. And that's what a temporary family law order is, and it goes along with a child support worksheet, as well as a temporary parenting plan. And the factors the court uses to decide on a temporary parenting plan are contained in RCW 26.09.197, and stability is the most important for those. So I'm going to share that screen with you real quick. I can figure out how to do that. Okay, so when a court is issuing a temporary parenting plan, what it's looking at is, the best interest of the child right here. And then in making the determination, the court shall give particular consideration to the relative strength, nature, and stability of the child's relationship with each parent, and which parenting arrangements will cause the least disruption to the child's emotional stability while the action is pending. And then the court also uses the residential provisions in the permanent parenting plan statute, which we'll look at in just a minute. And I want to emphasize that the biggest thing that a lot of courts will look at is stability. They believe that kids, when they're going through kind of the emotional and all sorts of turmoil of divorce, that the kids need to have as much stability as possible. And so one of the things that you need to be arguing, and you need to have an attorney to help you argue is, why is my parenting plan promoting the most stability for the kids? And so when you're going through and you're filling out that parenting plan that we just looked at, when you file your declaration along with that, that's one of the things you need to talk about. Why is my parenting plan in the best interest of the children? And why do I believe that my parenting plan will provide the most stability for the children? And then one of the things that you need to understand is when you get a temporary parenting plan in place, that is kind of the new stability for the children. This is how the children's lives are going to be ordered until your final parenting plan is signed, when your final dissolution documents are signed. And so whatever your temporary parenting plan is, the court will be very inclined to adopt your temporary parenting plan as your final parenting plan. So you need to remember that, and you need to have an attorney that knows that when you're drawing up your temporary parenting plan, because a lot of times a court will adopt what the residential schedule is in the temporary parenting plan as the final parenting plan. So you need to be aware of that when you're telling the court what you think the temporary parenting plan should be. And finally, permanent parenting plans are under RCW 26.09.184. And that statute is much more in-depth as far as what should be in a parenting plan. And let me go ahead and share that screen real quick. So this is RCW 26.09.184, and it tells the court from the legislature what are the things the court needs to look at when it's deciding on a final parenting plan. And again, remember that in a temporary parenting plan, the court is also looking at the residential provisions of this statute. So the objectives of a permanent parenting plan are to provide for the child's physical care, maintain the child's emotional stability, provide for the child's changing needs as the child grows and matures in a way that minimizes the need for future modifications to the permanent parenting plan, set forth the authority and responsibilities of each parent with respect to the child, consistent with the criteria in the other two statutes. And again, 191 is the one that has to do with the problems, the reasons for limiting parenting time. Minimize the child's exposure to harmful parental conflict. Encourage the parents, where appropriate, under the other statutes, to meet their responsibilities to their minor children through agreements in the permanent parenting plan rather than relying on judicial intervention, and to otherwise protect the best interest of the child. And then the contents of the permanent parenting plan, kind of tracks the form that we looked at. One thing that's good is that in establishing a permanent parenting plan, the court may consider the cultural heritage, and religious beliefs of the child. And if that's something that's part of your family and something that's important to you, you need to make sure that that's part of your proposed parenting plan. And then considerations, the dispute, the different sections: dispute resolution, allocation of decision-making authority, and then residential provisions. And this is the section that is included that the court also considers when looking at temporary parenting plans. A residential schedule which designates in which parent's home each minor child shall reside on given days of the year, including provision for holidays, birthdays of family members, vacations, and other special occasions. And that's a lot that has to go into, of course, consideration of a final parenting plan. But again, it tracks the form, and the court is given guidance as to kind of how they're supposed to do things and the factors they're supposed to consider. But when the court is looking at a final parenting plan, they're looking always at the best interest of the child for all these different areas that affect a child's life. And that's about it for today. I need to get going, but I'm always happy to answer questions. I'm always happy to discuss your case with you. We do consultations here, and if you want to give a call and set up an appointment, I'm certainly happy to talk with you more about parenting plans, more about dissolutions, more about strategies for trying to deal with various issues that happen in families, and trying to get the parenting plan that you as a parent believe is in the best of your children. Again, I'm Susan O'Toole, and here's my email address and the phone number of our law firm, and they can put you through to me, and I'm always happy to talk with you. Have a great day and take care. Bye-bye.